operating the aircraft, management, leasing, time sharing, and control. Hello again. This is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Now, let's turn to the second layer of contract terms, the agreements that govern how the aircraft will actually be used after closing. This is where transactional lawyers sometimes draft in one lane while operations personnel live in another. This disconnect is dangerous with large turbine aircraft because the federal aviation regulations care much more about actual conduct than elegant labels. The first operational contract term to get right is who possesses or who has possession, as well as who has operational control. Under 14 CFR Section 1.1, operational control means the exercise of authority over initiating, conducting, or terminating a flight. As a practical matter, in a dry lease, that lessee normally exercises operational control, or in a wet lease, it is typically retained by the lessor or operator. That may sound simple, but this is where many expensive aircraft structures start to fail. A management agreement may say the owner retains operational control. A dry lease may say the lessee selects the crew. But if the manager sources the pilot, schedules the trip, directs the dispatch decisions, and presents the aircraft to users as a turnkey transportation product, the paper may not match the actual operation. For large civil aircraft under U.S. registry, 14 CFR 91.23 imposes truth-in-leasing requirements. Section 9123 requires a signed copy of the lease must be mailed to the FAA within 24 hours of execution, that the first lease flight requires notice to the FAA at least 48 hours beforehand, and that the lease must contain the required truth-in-leasing clause in large print immediately before signature. The memorable lesson is this: for large aircraft, lease language is not merely private drafting. It is regulated drafting. The second contract family is Part 91 Subpart F arrangements. Section 91.501 allows certain operations that are not common carriage, including time sharing, interchange, and joint ownership. But the definitions and change limits matter. A time sharing agreement under Section 91.501C1 is an arrangement whereby a person leases the airplane with flight crew to another person. And Section 91.501D limits what may be charged for those flights, often 2 times the cost of fuel and other ancillary expenses. Clients often hear the word timeshare and think flexibility. What the regulation actually offers is a narrow reimbursement mechanism inside a defined operating framework. So the agreement needs to match the exact authorized structure, the permitted charges, the flight purpose, and the actual operator on the day of flight. A good example is the recurring problem of using a management agreement, a dry lease, and a side letter together to create what economically charter, but contractually described as something else. The FAA's Safe Air Charter guidance warns pilots, owners, and operators to ask whether the dry lease is truly a dry lease, whether the lessee really has operational control, and whether anyone was coached on what to say if the FAA asks questions. That warning is not theoretical. In 2024 Department of Justice settlement involving Campbell Oil and EAS, the government alleged the defendants used sham dry leases that purported to lease aircraft without pilot services, while in substance the aircraft were made available together with pilot services and were held out to customers as air charter. The settlement resolved those allegations for $700,000. So, when drafting or reviewing a management agreement, a dry lease, or flight use agreement, you should remember And recall four things. Who chooses the pilot? Who can say no to the flight? Who controls maintenance and return to service decisions? And who is economically benefiting from the transportation service? The third key contract term is insurance and indemnity alignment. In aviation, indemnity language is not only as good, it's only as good as the insured structure and the operational facts behind it. The purchase agreement, lease management agreement, finance documents, and pilot requirements should not describe different insureds, different named operators, or different permitted uses. Another term clients underestimate is the covenant package. Large turbine agreements should not contain ongoing covenants or maintenance tracking, records preservation, approved flight qualification, hangarage, export compliance, where relevant, lien prevention, and cooperation with filings, notices, and inspections. Those are not decorative promises. They are instructions for keeping the structure bankable and defensible after signing. Here's something to remember. The operating agreement should not tell a different story than the flight department. A practical example makes the point. Suppose an owner acquires a Gulfstream through an LLC, signs a management agreement, enters into an occasional time-sharing arrangement, and wants flexibility for affiliated company use. If the documents are coordinated, that can be structured lawfully. If the owner copies internet forms, ignores 9123, misprices time-sharing charges, and leaves operational control language inconsistent across agreements, the aircraft becomes a compliance trap with wings. In short, the second category of key contract terms is about use, control, reimbursement, insurance, and ongoing covenants. Those terms matter because most aircraft problems after closing arise from conduct that the contract either misunderstood or disguised. Here is something to remember and take away. In large turbine aviation, a good operating agreement does not just permit flights, it proves why the flights are lawful. Thank you for your interest in this topic. This information is provided for informational purposes only, and it should not be construed as legal advice. Questions are always welcome. Please direct them to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues and answer your questions with precision.